Hello and welcome everyone. Welcome to another Lawdit podcast. So my name is Laura Krustiva. I'm a trainee solicitor here at Lawdit, and today I have the pleasure to be joined by Izaz Ali, who is a solicitor, advocate and founder of the firm, and we will be talking about, drumroll, Izaz, over to you.
Employment dismissal, yes. Because we were working on a case earlier in the week and we thought it'd be prudent to just sort of run through two aspects of it, unfair dismissal and wrongful dismissal. So back to you, Laura.
Yes, so thank you very much. So actually, there are three types of dismissals when it comes to employment law. We'll just be discussing two of those because the other one would require its own podcast. But if we just dive straight in, so with unfair dismissal being the first of three types. So this type of dismissal refers to when your contract, if you're an employee, has been terminated without a valid reason, or when it's not been in compliance with the legislation of employment laws. Okay, so when we say unfair, this means that there is no just reason, and it's just been completely unreasonable. And if you have been, finding yourself in the unfortunate situation of being unfairly dismissed, and you do wish to commence a claim, there are three requirements which you need to satisfy. So these are the grounds that we would look for when we're looking at whether you have grounds for a claim. So firstly, you must be an employee as opposed to a worker or any other definitions. So you must be an employee who's worked for a period of 2 years, starting at the date of the employment. This is how we calculate the 2 years. So it's when you first start your employment up until the what we call effective date of termination, the ETD. That is when it ends. And there must be a period of 2 years in between, and you must be an employee in order to tick the first two boxes of having successful grounds for a claim. You also, just a side note, shouldn't be an excluded class of an employee. This includes being in the military or being a police officer, crown workers, etc. And you must have been dismissed from employment. There are 5 reasons that are classed as fair in the Employment Rights Act. So if you're dismissed for any one of those reasons, and your employer can show any one of those reasons, then they would have been deemed to have acted justly in dismissing you for any of those reasons. And employers should always follow very fair and very transparent procedures when considering dismissing an employee. So this is a note to both employers and both to employees to consider. So it includes giving notice of termination, providing you with a valid reason as to why you've been dismissed, and also, very importantly, whether you're an employer or you're an employee, you must have an opportunity to respond, or you must give your employee an opportunity to respond as to why you're being dismissed. And you must offer support where you're able to if you're an employer. This can minimize the risk of a claim from an employer's point of view. However, if you feel as an employee that none of these actually apply to you, then this increases your risk for your chances of having a potentially successful claim. So those were the things to run through. We can dive into the actual 5 permitted reasons as being fair, probably in another podcast, as that would need some exploring, but it's legislation. It's something that can be viewed online, or you can contact us if you need further guidance. But that's essentially the rundown on unfair dismissal. You must be an employee, you must have worked for a period of 2 years, and you must not have been dismissed for one of the 5 permitted reasons. And now, Izaz, if I may ask you to run us through wrongful dismissal, please.
So, in contrast, wrongful dismissal is effectively covers a situation where typically an employer terminates an employment contract, and in doing so, he's breached the terms of the contract, or effectively it's a violation of law. So wrongful dismissal can occur where an employer dismisses an employee without giving proper notice. That, for us, is the most common ground that we come across. And secondly, and usually in addition to that, it's a dismissal without following proper procedure as either set out in employment law or in the employment contract. So it's really, really crucial that it's dismissals where proper notice hasn't been given and or the proper procedure has not been followed. In addition to that, if an employee wants to make a claim, there's no limit in terms of the minimum amount of work that they've been involved in that organisation, so the term of service doesn't come into play. And effectively the remedy that they're seeking is, hey, employer, you've done this wrong, you're in breach of contract, I want damages for the pecuniary loss that I've suffered. And also that it would effectively be the point to cover off there. In terms of how long they have, i.e. an employee has to bring a claim, it's 3 months from the actual date of termination. And it's important, that aspect of it. Another sort of side comment, but something equally important, we've come across this on a case, and that is that an employee can't make a claim unless they've actually been dismissed. So that might be a statement of the bleeding obvious, but we have come across these sort of situations in the past. So dwelling upon that a bit further as to the circumstances, so no proper notice given, or the employer's breached what we would refer to as a fundamental term of the employment contract. Could be failing to pay the employee's salary, or honouring the holiday entitlement or holiday allowance, etc. But it does extend to other aspects which would include the sort of heavy areas of employment law in terms of payouts, and those are the discrimination grounds, the harassment grounds, retaliation for whistleblowing or for an employee exercising their legal rights. Another thing that we came across actually on a case that Laura and I were working on together, and that is that if an employee commits a repudiatory breach of contract, then the employer is allowed again to dismiss without notice, and that would be in the serious cases like theft, gross misconduct, leaking of confidential information to a competitor, all that sort of stuff. And in terms of what an employer can do to ensure that he complies and that he avoids any of those sort of problems, it's really a case of having a good employment contract, having set procedures for grievances and disciplinaries, and actually going through all of that and making sure that the employer is aware of those practices and procedures, and then if an incident occurs, to actually follow those procedures. And that would help to battle away any claim in relation to that. So in terms of sort of moving forward, if you follow those practices and procedures, provide proper notices to an employee when you're terminating their employment, make sure that you pay the final salary, any holiday entitlement that they're entitled to that remains, any benefits that remain, and ensure that the termination is not as a result of discrimination or whistleblowing or any of those sort of grounds, then you ought to be fair and covered there. One final thing, as a protective measure, one ought to consider entering into a settlement agreement with an employee whereby you set out the terms and conditions as to the departure, and you will provide a small allowance for the employee to go to seek independent legal advice, and for them to get sign off on the document by the legal advisor to say, I've run through these terms, employee confirms that if he receives these sums set out in this agreement, he doesn't have any further sort of complaints against his employer. And it's a nice way to sort of close off that sort of situation.
Thank you very much for that, Izaz. That was very useful, and hopefully very useful to our listeners. And that will actually conclude our podcast for today. So we covered both unfair dismissal and wrongful dismissal. So please do keep an eye and an ear out for a constructive dismissal podcast coming to you in the near future. Thank you very much for listening, and we will see you soon.
Thank you. Bye.
Thank you.